On March 7, 2020, 23-year-old Keelin Hawkins was arrested and charged in the Harris County Criminal Courts with driving while intoxicated. That same day, she was released on a so-called general order bond under Harris County Local Rule 9, which requires that with the exception of defendants in certain so-called carve-out categories, all misdemeanor arrests must be given an unsecured personal bond and promptly released without the need for a judge to sign off first. In other words, for most misdemeanor arrests in the county, release happens automatically, and the sheriff is instructed to let the person go without collecting an upfront payment or holding a separate in-person bond hearing. Harris County's general order bond system is unique as it was created as part of the November 21, 2019 consent decree resulting from the 2016 class action lawsuit of O'Donnell v. Harris County, which alleged that the county's then existing misdemeanor bail practices were unconstitutional. The consent decree imposed bail reforms in Harris County, including the implementation of the general order bond. After Ms. Hawkins was released on a general order bond, her arraignment was scheduled for March 13, 2025 in the courtroom of Judge David Fliescher, who was tasked with determining whether there was probable cause to support the DWI charge and revisiting the issue of bail. Ms. Hawkins's defense attorney of record was Greg Holton, but Mr. Holton's colleague, Aaron White, handled the arraignment.
Good morning, Ms. Hawkins. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On March 6, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy eyelids, and a strong odor of an alcoholic beverage. The defendant admitted to drinking 1.5 alcoholic beverages, and the defendant stated she was buzzed but not drunk. An inventory search of the vehicle was conducted, and the officer found a large plastic cup that was 1/4 full of alcoholic beverage that smelled of tequila in the center console cup holder. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a specimen. A blood search warrant was signed and executed.
Are you telling me that she has alcohol in the car while she's driving?
She had a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds, ma'am. You're not allowed to drive. I'm taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for now.
After finding probable cause for the DWI charge, Judge Flecher placed so-called conditions on Ms. Hawkins's bond, ordering her not to consume any alcohol and not to drive at all, despite the fact that the prosecution in a written motion had only requested that Ms. Hawkins be required to install an ignition interlock device, or IID, which is a breathalyzer installed in a vehicle that prevents it from starting if alcohol is detected in the driver's breath. Under Article 17, 441 of the Texas Code of Criminal Procedure, judges must require defendants charged with repeat DWIs or aggravated offenses such as DWI with a child passenger to install an IID as a condition of release. Now, because Ms. Hawkins was a first-time DWI defendant, Article 17, 441 did not mandate an IID in her case. However, under Article 17, 4040 of the Code of Criminal Procedure, judges have broad discretion to impose quote-unquote any reasonable condition of bond related to the safety of the community. Now, while judges cannot use bond conditions as a form of punishment before conviction, as the 14th District Court of Appeals in Houston explained in the 2022 case of Ex parte Bucks, Appellate courts review challenges to bond conditions under a so-called abuse of discretion standard. This means that a trial court's decision will not be overturned so long as it falls within the quote-unquote zone of reasonable disagreement. Here, given the allegations that Ms. Hawkins was driving while intoxicated and had an open container of alcohol in her vehicle, it is highly likely that a reviewing court would conclude that Judge Fletcher's restrictions prohibiting her from drinking alcohol and from driving a vehicle were reasonably related to community safety and therefore not an abuse of his discretion.
Understood.
We can approach at a later date, but I'm
concerned because for her employment, she can't get to and from work, and we can't get an occupational license or something like this. It's a condition of the court. I don't think we have any opposition to putting an interlock in the vehicle so that she's not able to drink and then drive. But it just seems like no driving at all seems a bit harsh for a first offense. We don't even know what the blood is at this point.
Get it? But she has alcohol allegedly in the car while she's driving. One would presume that that's a humongous no-no, you know? And I want her to appreciate the privilege it is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and appreciates the privilege, you know, be proactive. It's not forever, Aaron, you know, but I want her to understand that it's a privilege, it's not a right, and it's something that people should take very seriously.
Your date. I mean, is there something we can do? Because, you know, if it's something that you'd like her to do while on bond to make sure that she's, you know, addressing the issue. I mean,
Be creative, be proactive. I want to know that she appreciates it, and I'm all ears, you know. But it's something that I've seen more and more, you know, where there's alcohol in the car, and I would presume that you would know, especially at this age, that, you know.
well, to be fair, Judge, the allegation is that she violated the law. The presumption is that you would know not to violate the law, period. I personally don't think that the fact that there is possible alcohol in the car, I don't think it's been tested, but it just seems like no driving at all seems like a harsh penalty for someone who's never been arrested before, no criminal history. These are allegations. There's a blood draw pending. According to the dim summary, she had 1.5 drinks. It's certainly possible her alcohol level comes back below the legal limit.
Mr. White argues for driving privileges so that Ms. Hawkins can drive to and from work, and Judge Fliescher maintains the zero driving condition of bond for the time being. It is important to understand that restrictions on driving as a condition of bond are separate from the status of an individual's driver's license under Texas's administrative license revocation process. Because Ms. Hawkins' blood test results were not yet available, her license was likely not administratively suspended at the time of this hearing. However, as we have discussed earlier in this episode, judges have broad discretion under Article 1740 of the Texas Code of Criminal Procedure to impose reasonable conditions of bond for community safety, which is why Judge Fletcher had the authority to prohibit her from driving entirely, and why he would also have the ability to permit her to drive to and from work while prohibiting any other driving. If Ms. Hawkins's blood results later came back showing a blood alcohol concentration of 0.08 or greater, then the Department of Public Safety would suspend her license under Section 524.012 of the Texas Transportation Code, which requires the department to suspend an individual's driver's license if they drive with a BAC exceeding the legal limits. Once Ms. Hawkins's license was suspended, even if Judge Fliescher lifted the bond restriction prohibiting her from driving or granting limited driving privileges, she could not lawfully drive unless she obtained an occupational driver's license under Section 521.242 of the Transportation Code, which allows limited driving for work, school, or household duties despite an administrative suspension.
And if that takes 90 days to get those lab results and come back and get this taken care of, she's not driving for 90 days.
I'm not saying that long, Aaron. I just want some kind of proactivity that I know that she appreciates come back and, you know.
And just
Hey,
for
you know.
fixed purposes, so I can convey this perspective. What's proactivity to the court?
Just be creative.
Okay.
Be creative. And, you know, several weeks, come back and we can talk. But it's a privilege. It's not a right. And it's something that we take very seriously. Every single day, someone dies from a DWI in our county. Every single day. And we need to ensure that it's taken seriously, you know? I'm not asking for much. And once we know that there's appreciation, then let's talk again. How's it going?
Oh, good. Thank you.
How has it been? Not tough, isn't it?
Yeah.
Sucks. Living in a city as big as Houston without the ability to drive blows. And the only thing that I'm trying to get to you is to understand that it's a privilege. It's not a right. Every single day on our streets, someone is dying from some kind of alcohol-related collision. That's what we're trying to impart to you here, to take it seriously. It's not a joke, and the last thing I want is for something like that to happen here. You understand? All right. I'll take off the restriction. Okay.
Judge,
What does she have now? I want to make sure that she has an interlock for now, just for a limited time.
Judge, if I could speak to that briefly,
Sure.
just to reassure the court that she fully understands the court position. I had her research and write an essay on alcohol-related accidents and fatalities. We can turn that in and take a decision-making course. Her case is a stop for expired registration, no accident. You got the blood this morning, it's a 1-3. She has no criminal history. So I would ask the court that to use the research she's done in the 28 days without driving at all to understand that she gets it. And if we can not have the interlock, as would have been if she didn't have an open container, that we proceed further and let us do the work of getting the discovery forward.
Okay.
I can turn both those in.
I want you to know, I will act to your lawyer, but if I find that you're using alcohol, I'm going to blow a gasket. I'm really just going to lose it. Just don't. That's all I'm asking you to do. Do you understand?
Yes.
Okay. I'll take a look at this. I'm going to acquiesce to you.
Thank you, Judge.
Just don't. Life is too short to spend the next month in a 6x9 box.
Mr. Holton informs Judge Flecher that Ms. Hawkins's blood test returned a BOC of 13, exceeding the legal limit of 0.8. Despite this result, Judge Flecher agrees to remove the no driving condition from Mississippi. Hawkins bond and at Mr. Holton's request declines to require the installation of an ignition interlock device. Nevertheless, because Ms. Hawkins' BAC was over the legal limit, it is highly likely that her license was subject to administrative suspension, meaning that she could not lawfully drive without either obtaining an occupational driver's license from the district court or successfully contesting the suspension. Now, since the administrative license revocation process is separate from the criminal proceedings, the matter was not addressed during this hearing, so I cannot speak to it definitively. However, as of the date of writing this episode, Ms. Hawkins' DWI charge is still pending. In this episode, we saw Judge Flecher using the broad discretion over bond conditions that he's granted in his authority as a judge to bar M. Hawkins from driving and from consuming alcohol, even though the state had only requested an ignition interlock device. About a month later, Judge Flecher exercised that same discretion in another hearing to remove the no driving condition, even declining to require an IID. Bond conditions are tools that judges use to address community safety issues while allowing criminal defendants to remain out of custody while their case is being adjudicated. Now, while some viewers may find the initial restrictions unfair given the limited record before the court at arraignment as the blood alcohol results were not yet back and the contents of the alleged open container had not been tested, others will view those limits as cautious temporary measures intended to reduce risk while the case is pending with the expectation that judges will revisit and recalibrate conditions as new information arrives, which is what happened here. Either way, judges have broad authority under Texas law to set reasonable safety-related bond terms. So, the initial driving ban was almost certainly lawful, even if it felt strict or unfair to Ms. Hawkins. Let us know if there's a case or courtroom interaction that you'd like us to cover in the comments below. Thank you for watching and don't forget to subscribe and share so that we can help foster a more informed society.